Hello and welcome to In Solidum Lawyers. Today we are going to unravel the tangle of alternative conflict resolution methods. Ready to discover the key differences? Let's go! Conflicts and disputes are inherent to social and business dynamics, posing not only challenges but also opportunities for understanding and effective resolution. In Ecuador, mediation, negotiation, and arbitration are alternative methods to judicial resolution of disputes, each supported by a solid legal framework that facilitates their implementation and promotes their effectiveness. Ecuadorian legislation, through the arbitration and mediation law, among other initiatives, underscores the country's commitment to peaceful conflict resolution. These methods offer significant advantages in terms of time, cost, and long-term relationship maintenance. We will delve into how each of these mechanisms operates under Ecuadorian regulations, exploring their benefits and particularities. This analysis seeks to provide a clear understanding of the available options for conflict resolution outside the traditional judicial realm. Mediation is a structured and confidential process where a neutral mediator facilitates dialogue between the parties in conflict, allowing them to jointly develop a consensual solution. Unlike a maze without a guide, the mediator provides direction without imposing a result, focusing on building bridges of understanding. In Ecuador, this process is based on voluntariness, equality, neutrality, and confidentiality. It represents a peaceful alternative to litigation, seeking mutual benefits and preserving long-term relationships. The mediator, more than an arbitrator, acts as a facilitator of dialogue, ensuring that the discussion remains productive and focused on the underlying interests of the parties. The success of mediation is measured not only by the immediate resolution of the conflict but also by the maintenance of future relationships and the creation of sustainable agreements. This approach requires the parties to take responsibility for negotiating in good faith with the aim of transforming disagreements into opportunities for understanding and joint growth. In the realm of conflict resolution, negotiation and mediation represent two different approaches with the same ultimate goal: resolving disputes and preserving relationships. Mediation is characterized by the intervention of an impartial third party to facilitate dialogue between the parties, whereas negotiation involves a direct and active exchange between the involved parties without the presence of a mediator. Negotiation is defined by its flexibility and adaptability to the specific circumstances of each situation. In Ecuador, this process tends to be more informal and can develop without the need to follow strictly established procedures, allowing the parties to adapt the process to their specific needs. This direct approach allows the parties to control the negotiation process, exploring potential solutions and working together towards a mutually beneficial agreement. The effectiveness of negotiation lies in the parties' ability to communicate effectively, exchange concessions, and find common points of interest. Thus, negotiation becomes a dynamic process where each party plays an active role in building the final solution, highlighting the importance of mutual trust, respect, and shared commitment to a common goal. Arbitration emerges as a fundamental component in conflict resolution in Ecuador, offering parties the option to submit their differences to an impartial arbitrator whose decision, the arbitral award, has the authority of a judicial sentence. This mechanism is firmly supported by Ecuador's arbitration and mediation law, establishing a legal environment that promotes autonomy, equity, and justice, making it particularly attractive for resolving commercial disputes due to its efficiency and confidentiality. The relevance of arbitration in the Ecuador context is highlighted by its ability to provide legal security to market actors, especially in an environment of growing international commercial interaction. The possibility of selecting arbitrators with a specialization in the disputed matter ensures grounded and appropriate resolutions to the specific context of each conflict. Arbitration not only positions itself as an alternative to the traditional judicial system, but also symbolizes a move towards a more modern and efficient justice management. It facilitates access to quick and personalized solutions, setting a precedent for conflict resolution that favors progress and collaboration in the business and commercial realm. This innovative approach to justice administration underscores Ecuador's commitment to developing methods that not only effectively resolve conflicts, but also promote an environment of cooperation and mutual development, paving the way to a future where legal challenges become opportunities for collective advancement. Mediation stands out in the context of conflict resolution for its efficiency and speed, offering a more economical solution by reducing legal and arbitration costs and facilitating efficient resource management. This allows parties to focus on priorities such as business growth or family welfare. One of the most significant advantages of mediation is its focus on preserving and improving interpersonal relationships. Unlike arbitration, which may result in winners and losers, mediation seeks mutually beneficial agreements that promote understanding and collaboration between parties. In Ecuador, the current regulations strongly support the use of mediation as a preferred dispute resolution mechanism. This legal approach emphasizes the importance of resolving conflicts peacefully and harmoniously, promoting a constructive dialogue environment that respects the dignity and interests of all involved. Therefore, mediation not only presents itself as a viable and effective alternative to traditional litigation methods, but also emerges as a pathway to conflict resolution that aligns the principles of justice with the values of peace and social harmony, solidifying its position as an essential tool in the Ecuadorian legal framework. In the Ecuadorian legal system, alternative to conflict resolution methods such as mediation, negotiation, and arbitration are effectively integrated thanks to a robust legal framework. This framework not only recognizes the validity of these methods, but also encourages their application, providing an effective alternative to traditional judicial processes. The arbitration and mediation law establishes clear guidelines for implementation of arbitration and mediation, ensuring legal security and streamlining dispute resolution. This legislation eases the burden of the judicial system and makes justice more accessible and efficient for everyone involved. Beyond establishing a legal framework, the legislation reflects a commitment to promoting peace and mutual understanding. By encouraging the use of these methods, Ecuador positions itself as a regional leader in seeking constructive, non-confrontational solutions to conflicts. This legislative approach demonstrates an innovative vision of justice, emphasizing the importance of dialogue and consensus in a dispute resolution. Ecuadorian legislation on conflict resolution calls for prioritizing mutual understanding and cooperation over traditional litigation. In Ecuador, alternative conflict resolution methods, specifically mediation, negotiation, and arbitration, are fundamental within the legal framework for offering effective solutions to disputes. These mechanisms stand out for their ability to facilitate dialogue and promote mutual understanding among parties, contrasting with the potentially longer and more confrontational traditional judicial processes. Ecuadorian legislation provides strong support for these methods, establishing clear guidelines that not only expedite the resolution process, but also help to alleviate the burden of the judicial system. This enables a more accessible and efficient administration of justice, focusing on the preservation of long-term relationships and the pursuit of mutually beneficial agreements. From our firm, In Solidum Lawyers, we encourage the adoption of these conflict resolution strategies in both professional and personal realms. We recognize the value of building and maintaining strong relationships, as well as the importance of addressing disputes constructively, seeking solutions that strengthen bonds between individuals and communities. Finally, we invite our audience to delve deeper into these alternatives to dispute resolution, to subscribe to our channel for updated content, and to share their own experiences and reflections on this subject. Promoting understanding and justice through these methods is not only fundamental to conflict resolution, but also crucial for the advancement of a more harmonious and cooperative society. If this journey through alternative conflict resolution methods has captured your interest, we invite you to become part of our community at In Solidum Lawyers. Subscribe to our channel to not miss any of our future legal explorations. Do you have experiences or doubts about these processes? Leave us a comment below. We love to learn from your stories and answer your questions. And if you believe this video can illuminate someone else's path, please share it. Your support is vital for us to continue growing and offering valuable legal analysis and advice. Thank you for joining us today. At In Solidum Lawyers, we are committed to being your beacon in the complex legal world, guiding you towards fair and effective solutions. Until our next meeting, remember, knowledge is power, especially when it comes to your rights and how to defend them. Until next time, and stay informed.